Bruce Rogo for the Arizmendi plaintiffs, appellants. In this case, I have to convince the court of two things. One, that Lewis versus Sovereign Bank is distinguishable and doesn't control this case. And two, that under 12 CFR 560.2, this is a contract case. And therefore, because it is a contract case, it is not subject to the field preemption that otherwise these kind of cases would be subject to. So the question is, what is the contract here, and why is this a contract case? The difference between Sovereign and this case is that Sovereign was a posting order case. And when I say a posting order case, what that means is that when debit charges were posted at the end of the day in the Sovereign situation, the bank would post them in an order that began with the largest first. They would resequence the debit card charges, and by resequencing the debit card charges, they ended up, in using the largest first, they ended up creating more overdraft fees. So the difference between that case and that contract in the Sovereign Bank case is that that was a posting order case. This is a contract case because we are resting on the words of the contract. And the words of the contract here in the Sovereign Bank, in the Atlantic Bank Agreement, is items presented when paid. That's really what this is talking about. In the event that an item is presented for payment, which, if paid, would cause your account to be overdrawn, we reserve the right at our discretion either to return the check or pay it, etc., etc. So we are resting on the language of the contract. They have said that when they pay this item, they decide whether or not there's going to be an overdraft.
Let's go with that for a minute, and let's argument purposes agree we're talking about a contract action. Okay. In paragraph 67 of your complaint, you give an example of overdraft fees regarding the account of Jesse Rowe. And you break the example up into two parts. And in the first part of the example, you give a balance sheet analysis of how money was processed, being withdrawn from the account. And then in the second part, you give a balance sheet analysis of the transactions from the debit card activity report.
Yes.
Okay? In both examples, in the far left-hand corner, you have a column that says date posted for both examples. What strikes me is the word posted in that context means two different things between the first example and the second one. So my question is, if in the banking world, posting can mean different things, then why can't the words pay, payment, and paid mean different things?
Because this comes out, of course, from their records. This is the way their records show how these point-of-sale purchases were handled. And if one takes a look at that, it's page 2485 in the record on appeal, it talks about POS purchase, point of sale purchase, and 329. So that was paid from the account. In other words, posting it later on.
Yeah, but the posting refers to, when an activity gets registered, so to speak. And in the first example, you're using posting in the sense of this is the manner in which we dispersed money out of the account. When you use posting the second time in the bottom part of the example, there you're talking about posting in the sense of that's when the customer used a credit card or debit card, whatever, and purchased something. So again, posting in one instance means how you pay something out, and another instance means how the cardholder or how the client used the money. So again, posting is a word that depends on the context of what it is that you're talking about. So it certainly seems to me that, are you talking about what the account holder is doing? That might mean paid or payment or whatever, as opposed to what the bank is doing, where in that context, paid payment or pay may mean different things. So again, it just strikes me that if you're focusing on language in the contract, I think we have to understand that in the end, what we're really talking about is the language that the bank at the top of the agreement basically says, when processing withdrawals from your account. And that seems to me to kind of set the framework of what the sentences after that are in the context of, aren't they?
It does, and the processing of the withdrawal from the account on the point of sale purchase is there at 12:51:08 p.m. They have it listed under posted, but that's $3.29 that was paid for the purchase, the Shell, the gas station. Next thing is Wendy's. So at that moment, when Wendy's was paid.
But you're saying paid in the sense of that's when the account holder went out and bought something. But that's not necessarily the same thing that the bank is operating on when they're talking about this is how we're going to remove money from your account and move it elsewhere.
Well, looking at the contract, I mean, I read the contract as when it says, in the event that an item is presented for payment, which if paid would cause an account to be overdrawn. So aren't they paying that? Isn't the Shell station getting the $3.29 that comes out of the account? It's paid.
But isn't it also more likely that what that language is referring to is in the context of how we're going to transfer money out of your account, we're going to process payments. In other words, reduce your account because we are now honoring our obligation to pay things that you incur. It seems to me that they're talking about if in the process of making that transfer out, it appears to us that you're now overdrawn, you're going to pay fees. And clearly, they put the customer on notice, we're going to pay the highest amount first. I mean, that's seemingly so clear. So I'm just struggling with trying to understand. You're using paid in the sense that, well, once the customer hands the card over and purchases, that's the way that the money has to be transferred out of the account. And I'm not reading the contract language to say that.
And I am reading it that way, that Shell was paid, that Wendy's was paid, because at that moment.
But that doesn't mean that any money was transferred out of the account.
Well,
because it's when Shell then says to the bank, give me my money, that the bank then has to kick in and start transferring money out. And they clearly say, well, if we get multiple things coming in at the same time, we can go ahead and pay the highest first.
Let me take the second part about the multiple things. Secondly, first, let me address this, that it's the person who has the account who reads this agreement and reads it to say, when paid, they will pay it. So I'm reading paid the way I think an account holder would read paid, that when he pays or she pays Shell and pays Wendy's, there's money in the bank. There's money in the bank. Those people are paid. I mean, that's the whole point of sale arrangement. That's why people like debit cards, at least vendors like debit cards, because they're getting paid right away. So so the difference then is between Sovereign Bank, which talks about posting order. So there is notice in the Sovereign Bank situation that this is a posting order, that we can post this in any kind of way we want, and we'll go highest to lowest.
Why would you need to say that it is our policy to pay the largest item first if they were paying in the order of time?
Because if checks come in, for example, if two checks are presented and one check is for the rent and it's $900, the bank would pay that first if there's $1,000 in the bank, so you don't get evicted from your house. So the idea of paying the largest first stems from the checking situation where you have a bunch of checks coming in. It's a different situation.
Well, but if it says checks, point of sale, ATM machines, withdrawals, it doesn't just apply to checks. It seems to apply to everything. If they were just going to pay time based on the time of the transaction, they wouldn't need to say pay the largest item first. It'd say we will pay based on the time the transaction hits our system. Would they not?
They would, except that in this situation, we're just focusing on the debit charges because the debit charges lead to the overdraft charges. And the multiple overdraft charges are the product of them. They've paid this money. So if you look at the account holder, if this person is keeping track of their account and they know they've got $13.30 in at the beginning, and they say, okay, I'm good, I can buy $3 worth of gas, I can buy $6 worth of food at Wendy's, so I'm okay. And then $15, okay, now I know I've overdrafted, it's going to cost me $35 for that. Because if they're focusing on the language of this agreement, then they know that they are good until that last purchase.
Let's go then with your example of two checks come in at the same time.
Yes.
Okay? Help me out with the concept of how do you know two checks actually, can two checks even come in simultaneously? And isn't there some kind of sequencing where one check gets there before the other? I mean, then is it a question of who gets to the bank for? I mean, it's just hard to imagine that two checks are simultaneously going to show up at the same time. So even in the concept of checks, it seems to me that there's going to be a certain sequence of when things are presented for payment, isn't there?
There certainly could be. I don't know if they always will be, but if different checks have been written and they're deposited in different banks by the retailer, and then the bank sends them, they may all come in at similar times to the bank, to Atlantic Bank, and they take a look and they say, okay, this one's for rent. We're going to pay this first, and that is the history. That's why the largest got paid first was to protect people in the checking situation. The debit cards, of course, came afterwards because debit cards are relatively recent.
You think this agreement was drafted to protect the customer? I mean, or it seems like this is a more honest contract than the one in Lewis versus State Bank, because in this case, the bank says exactly what they're going to do, how they're going to post it. They're not cagey about it like the one in Lewis Bank.
The bank in Atlantic doesn't talk about posting it. That's why I think that the Sovereign Bank case is a more honest kind of communication, because in the Sovereign Bank case, it says we will post in any order that we want to post. Here it says, and it does talk about obviously paying largest first, but it says, and this is the language, in the event that an item is presented for payment, which, if paid, would cause your account to be overdrawn, we reserve the right at our discretion to do it or not do it.
If we disagree with your construction of the bank's contract with the customer and construe when paid to be synonymous with posted, would you agree then that Lewis versus Sovereign Bank and the reasoning there would control?
Yes. But in this situation, I've got 2.5 minutes, I'm going to reserve 2, but in this situation, the difference between the language in Lewis and the language in Atlantic Bank is very important. They use posting. They do disclose that when we post. Here they say, when we pay, we'll decide if there's an overdraft. And in this situation, it is the contract language that they chose, and as a result, this is a contract case and it's not preempted.
May it please the court, Gene Stearns and Abby Corbett for BB&T, which was Bank Atlantic. I don't believe it's necessary to read past the agreement itself, which addresses specifically point-of-sale transactions. It says, when processing withdrawals from your account, such as those made through checks, in-person withdrawals, automated teller machine, point-of-sale, ACH transactions, or by any other electronic means, it is our policy to pay the largest item first. This payment policy may increase the occurrence of your receiving fees for insufficient funds. So what the agreement specifically contemplates is a sorting procedure, processing procedure, in which all of the items presented, including point-of-sale items, are treated collectively, and they will be paid or processed in the order of size.
But this concept of when presented, I guess, is also a bit of a problem in the sense that, what does that mean? Are you talking about within a 24-hour period? Are you talking about during normal banking hours? I mean, what is that concept when presented? What time frame does that normally connote?
Your Honor, I think you have to look at the entire deposit agreement. For example, Mr. Rogo's incorrect about payment, for example, of point-of-sale items. Point-of-sale items get a pre-authorization hold. It's not paid. The vendor who takes a credit card, a debit card, is assured, once that is approved by the institution, that it is going to be honored when presented. It doesn't get paid until it is later presented. And in fact, the agreement specifically provides it typically occurs at gas stations or at restaurants, where it's a pre-authorization before the gas is put in the vehicle or before the restaurant sends a bill. It's typically a tip is put on an invoice. And so what the bank agreement provides is we're going to honor that amount that is the pre-authorized hold, and that's governed in the agreement. You're going to see this in the record at 2974, which is the pre-authorization hold disclosure. And all that says is that it contemplates the process by which there will be pre-authorization of a point of sale item. But certainly, for example, in any given banking day, you will expect to see items presented for payment during the day. You'll expect to see deposits presented during the day. You'll expect to see deposits made in prior days cleared for payment in subsequent days. And at the end of the day, all of these transactions are then sorted through the process contemplated in the deposit agreement. But at the end of the day, what this is ultimately, and while Mr. Ruggo talks about sovereign being the guiding light here, and it certainly is instructive, the regulation, the statute itself that Congress passed a long time ago is quite clear. And if you look at 12 CFR 557.2, it preempts state law that purport to impose requirements govern checking accounts, disclosure requirements, funds availability, or service charges and fees. That's what Congress did when it adopted the Homeowners Loan Act, which was to provide sweeping field preemption for savings banks for a public policy, and was to avoid the kind of artful pleading such as exists here. And while there is an exception for contract and commercial law, it's an exception only if it, quote, incidentally affects your deposit-related activities.
So can you give us an example of something that you believe would be incidental, a type of lawsuit that would be
Example would be you have $10,000 in your account, an item is presented for $1,000, and you charge a fee for an overdraft when the overdraft doesn't exist. That's a clear, bright line. You violate that. That's not protected under field preemption. There were claims in this case to that effect, and Judge Streitfeld did not grant dismissal of those claims. Remember, this case went through, I think, 7 different complaints before we get here to try to artfully to come up with some theory that would survive a motion to dismiss. Count 3 is the last one that's left and addresses point-of-sale transactions, which is puzzling because point-of-sale transactions are specifically addressed in the deposit agreement itself and specifically provides that those are among the items that will, quote, be processed highest to lowest. As a disclosure case, which is essentially the argument, which is how would a customer have known this? How could a customer have known anything else? When all these means of payment are identified, they're told that they're going to be processed and they're told they're going to be paid highest to lowest. It is physically impossible not for some item to have not come in first, second, third, or fourth during a given day. There would be no point of that provision if the items were paid in the or sorted when they came in as opposed to highest to lowest. So respectfully, I think where we're looking at here is a case that is clearer than sovereign. Sovereign was a circumstance where the bank reserved the right to pay highest to lowest. Here, I think Your Honor has been quite correct. Here the bank was quite clear. We are going to pay highest to lowest, and therefore it will increase your exposure. I think the court in Miller versus Nationwide Life Insurance, which is the Fifth Circuit decision, 391 Fed 3rd 698, said that whether a claim is preempted hinges on the content of the allegations, not on the label affixed to it. And I think that's really what's the challenge here is ultimately challenging the high to low procedure for establishing insufficient funds. Or in Dixon versus Wells Fargo Bank, which was the District Court of Massachusetts, where it said courts must be wary of artfully pleaded attempts to use common law claims as a clandestine way of imposing requirements on federal savings banks that states otherwise could not enact through legislation or regulation. So what we have here is a preempted field preemption, which is the broadest possible preemption. Every inference and deference should be given to the federal regulatory scheme, which, by the way, there was a federal regulatory remedy. A plaintiff could go to the Office of Thrift Supervision, could file a complaint, and could seek restitution. It's not that there didn't exist a remedy, it's that there was no state law remedy since Congress had given field preemption for this entire area. So I think in light of the answers Mr. Rogo gave, I believe it is quite clear. I don't know that I would waste more of the court's time. I believe affirmance is required here. Thank you.
Thank you, Mr. Stearns.
At page 2 of our reply brief, comparing agreements, if the court would take a look at that, the sovereign bank agreement, the language is, the order in which you make withdrawals from your account may not be the same as the order in which we post these transactions to your account. They say very clearly, when you make a charge on your debit card, the order in which you make those charges from your account may not be the same as the order in which we post these transactions. That is not what is said in the Bank Atlantic agreement. They talk about when processing withdrawals, et cetera, et cetera. It's our policy to pay the largest item first. But the important language here that makes this a different case, and this is, I'm threading the needle here, no question about that, but looking at this contract, in the event that an item is presented for payment, which if paid, they don't say which if posted, would cause your account to be overdrawn, we reserve the right at our discretion to either charge you or not charge you. So this is a contract case. The example that Mr. Stearns gave with regard to a violation of the contract really comes into play here in a little different context. This is the account holder looking at this would say, okay, when they pay it, then I could get charged with an overdraft. But when you look at the record and you look at the contract and how we've laid out the account, you'll see that when it was paid, and it was paid, they could buy gas. He knew it was being paid. He knew he had $3 worth, and he knew he was still within his $13. And he knew when he went to lunch, he was still within his $13. And yet, at the end of the day, it cost him $105 for those three. That violated his agreement with Atlantic Bank, and therefore, the decision below should be reversed.
Thank you, Mr. Rogan.